Hello, my name's Andy Hill and I'm Head of Legal Publishing at Blues Professional. I'm here today with Deborah Fosbrook, co-author of a new book that we're publishing, Contract and Copyright Drafting Skills, as well as the co-author of The 80 Set of Contract Clauses and the Media and Business Contracts Handbook. Hello, Deborah.
Hi, Andy.
What do you think the starting point is for drafting a contract?
Well, personally, my starting point is to do some research and look at the company, look at the business context in terms of where that contract is going to fit in. So you've got to understand the business of both parties in terms of what clauses are actually relevant, because if you don't understand what the other business is going to do with it or not do with it, then that's going to affect, how you put the contract together. So if they're not going to exploit some rights, then you don't want to have those rights given to them in the contract.
And how do you undergo that research?
Well, you look at their website, you look at their marketing department, you look at their annual report and accounts. You really and you understand the market. So if you're doing a merchandising agreement, you understand the merchandising market. If you're licensing a video, or if you're licensing a download, or you're licensing household item, what is the market? Where are they going to sell it to? Which territories are going to be selling it to?
And what do you find the hardest part of the research?
I don't find it hard at all. I quite enjoy it. To me, that's part of the, I enjoy the commercial aspect of it. To me, that's what contracts are about.
Okay. And when you're drafting a contract, what are the things that you really think, once you've actually started the drafting, that you really need to look out for?
Well, I think the thing is, first of all, most people are just presented, if they're not looking at a template that they've got out of an archive from their company, they're presented with maybe 12 points by some director or finance director, some deal that they've concluded over lunch or some business meeting, and you've got to understand, you've got to make a decision based on those facts as to what sort of agreement you should be drafting in the first place. So, it may be that you should be doing a buyout and buying out all the rights, or should be doing a licensing agreement, you may be doing a sponsorship agreement. So you've got to take those facts, decide what sort of agreement you should be drafting, and then add clauses beyond what you've been given the instructions for to actually build a contract that works financially for the company. So, in my previous experience, I've worked very closely with a finance director, because it's all about, all these agreements that you're drafting are about making money. You're creating assets for a company.
Is there in your experience, an example of a particularly difficult contract that you had to draft?
I think there's lots of different, it depends what sort of agreement it is, but I've done all sorts of agreements: co-production, international co-production agreements, presenters agreements, huge distribution agreements covering lots of different sort of areas of rights and products. I don't think they're difficult, but what it's about is having a purpose and an aim that you're aiming for and what you want to achieve out of that. So with rights, for instance, it's about, a lot of people make the mistake of giving too many rights that they don't need to give away to another company. So they're not drafting it as tightly as they can. So they're making, the license period too long. They're giving them too many territories when they're not actually going to exploit it in those territories. They're not even really following the money trail for the royalties and the payments, and they're not putting in accounting provisions which are thorough enough. They're not even adding in right to go in and inspect records. So, it's really taking the whole picture and then thinking of it commercially.
And it's that commercial thought that's really
yes,
the
that's right.
underlies
It's the
any
key
contract.
to every contract, because you can't see copyright and contract in isolation. It's there for a function, and every successful business has, at the essence of it, a whole series of contracts on which that business is based.
Because basically, to do the contract, you are making the company money, aren't
Yeah,
you?
that's right.
That's the ultimate goal.
Yes,
So
that's
therefore
right.
you always
that's
need to
right.
keep that
And you're
commercial.
protecting the company, so you're isolating. You're reducing exposure to liability. You're reducing the threat of someone making a claim against the company, and so you're anticipating the future as well.
So what skills do you think you need to be an expert drafter?
I think you need to. It's about acknowledging your weaknesses and realizing, having, which this book does, it'll give you red flags in terms of areas. You think, well, I've got to think about that. So one of the common mistakes people make in contracts, for instance, is that they get so focused on what material exists now and what is being created now, or what they're giving to a third party, that they're completely blind to what's going on about in terms of new material and new rights which are being created in the process of this arrangement that's being set up. So they may enter into a contract, and yes, they own the copyright to the original material, but no attention is given to what material is being created in the future, new prototypes, new samples, new marketing material, and who's going to own that material. And then the failure to address the issue of ownership of material which is created in the future results in people, and there's been a big shoe company which did this. They commissioned marketing material for a new brand of a label for a shoe product. A graphic designer created it. They didn't put a buyout in place. There was no assignment. So when they went off to thinking, oh, we're going to register this as a trademark, well, they couldn't because they didn't own it. They never actually put the paperwork in place. So these contracts and this paperwork is crucial to a lot of other consequences in terms of, I always talk about it in terms of people creating an archive of contracts and an archive of copyright and intellectual property rights that they own.
So basically poor contract drafting can be the failure of a business.
Yes. Well, it's not, it has consequences. That's the point about it. It's can restrict what a company can do in future. I mean, there's been instances, for instance, where, people who performed for television companies in TV series years ago, they signed contracts, they got royalties for those performances, but only a very limited number of types of rights were specified in the contract, which they got royalties for. So when new rights came into existence, like the internet and downloads and other forms of exploitation, which are new because with new technology there's new rights, there was nothing in the contract that gave those people a right to get royalties from the exploitation of those new rights.
That was going to be a follow-up question, actually, on sort of developments that happen, such as, like you said, sort of downloads and apps and how that changes things.
Yeah.
How do you keep abreast of developments like that and make sure that you incorporate them into your contract?
Well, basically, you be very specific as to what you're licensing and what you're actually granting, as to how long the period is for, what territories you're giving it for, what form of exploitation you're allowing, and then you reserve everything else, including new rights that may be created in the future, so you don't fall into the trap of saying I can list everything, because you can't list everything. Next week there could be another new form of exploitation that nobody's thought about. But if you've reserved all the other rights that may arise and other forms of exploitation, the other mistake people make is that they don't separate ownership of rights from ownership of physical material. And that's a really fundamental mistake that people make. So when I'm drafting a contract, I look at not only who owns the rights, but who owns that physical material. So if a contract is terminated, I want that physical material. Is a reversion of rights clause in the contract? Who owns it when there's a dispute?
So why do you think there's a need for a book such as Copywriting Contract Drafting Skills now?
Well, I think this is a book that if I'd had it when I was in my early 20s, it gives you a sort of masterclass in contract drafting and understanding copyright. And most people learn this sort of technique in training as a solicitor or as a lawyer. They learn it in a commercial company, in a legal department or a marketing department. There's lots of people that deal with contracts. This allows you to pick a topic. There's 56 in the book, and then you can just look at logos, and we've got a whole number on logos, so you understand what are you talking about? What do you mean by a logo, as opposed to a trademark? Or you've got an indemnity clause, and what actually do you mean by an indemnity clause? So we give an explanation of the purpose and the what that means in reality, and then we give you examples of clauses and how it can be varied. So how do you want to make the indemnity clause wider? Do you want to limit it? Do you want to financially limit it and set a cap on it? Is there a process in place for a procedure for someone to make an indemnity clause? Does the indemnity survive after the contract has been ended? So there's it allows you to look at a clause and feel quite confident that you understand how you can move things around and change things, and it gives you a view on aspects of contracts that makes you more positive in terms of being assertive about, well, I'm going to amend that clause, that's coming out, we're putting a new clause in the contract, and you've got structure to it. So, you know, I mean, we cover all sorts of areas. We've copyright clearance. Copyright clearance is a big issue in a lot of subjects, and not just to do with clearing material for things like marketing material and stuff like that, but also the cost impact of that. So, you know, each of the topics really gets to grips with, so you understand the basic essence of it. And if you understand what the focus of the clause is about, then you understand how it can be changed. If you don't have the basic understanding in the first place, you're going to struggle, because at the back of your mind is like, I really don't get what this is about.
Yeah. So I suppose following on from that, what would be your key piece of advice to a contract drafter?
The key piece of advice for anybody, I think, is not to get overwhelmed by, you know, you're presented with a contract which is 20 pages long. Don't get overwhelmed by it. Have the confidence to pick each issue as it goes, and to also be quite innovative and not bother about, you know, it's not about, this book is not about there's one way to draft a contract. There isn't one way to draft a contract. Everybody develops their own technique, their own style, but it's about clarity. You know, it's about actually drafting something that when someone reads it in 10 years' time, it makes sense. And if it doesn't make sense logically in plain English, then really you're going in the wrong direction. You need to, you know, so you get your definitions very clear. You're very specific about what the territory is. You're very specific in terms of what the obligations of each of the parties are. And don't, you know, if it's a tangled mess, then break it down into lots more clauses. You know, you've got to unstitch it really. That's
the key piece of advice.
Yes.
That's great. Many thanks, Deborah.
Thank you.